Hello, everybody. I'm attorney Vincent W. Davis, and today we're going to talk about one of the most stressful and confusing situations a parent can ever experience. We are going to talk about how to handle a divorce case when California Dependency Court becomes involved, and more importantly, what you can actually do step by step to protect yourself, protect your children, and protect your future. Now, if you are watching this video, there is a good chance that you are scared, overwhelmed, confused, angry, or maybe all of those things at the same time. Maybe you are going through a divorce or a custody battle, and suddenly allegations have been made. Maybe someone contacted Child Protective Services. Maybe the Department of Children and Family Services showed up at your home. Maybe there are accusations of neglect, abuse, domestic violence, substance abuse, emotional abuse, parental alienation, or unsafe living conditions. And now you feel like your family law case has exploded into something much larger. One day you are arguing about custody schedules, visitation, and child support in family court. And the next day you are dealing with social workers, investigators, emergency hearings, detention reports, supervised visitation, and dependency court judges. What makes this situation even harder is that many parents do not understand that dependency court operates very differently from family court. The rules are different, the procedures are different, the standards are different, the timelines are different, and the stakes are incredibly high. In dependency court, the government can seek to remove your children from your custody. So in this video, I am going to walk you through the practical how-to aspects of dealing with these situations under California law. We are going to discuss what dependency court is, how it overlaps with divorce and custody disputes, how allegations are investigated, how evidence is used against parents, how to challenge bad evidence, how to prepare for hearings, how to document your case, how to work with witnesses, how to preserve issues for appeal, and what legal remedies exist if you lose at the trial court level. This is going to be a practical strategy discussion. I want you to understand the process. I want you to understand the law. And I want you to understand the mistakes parents make that can seriously damage their cases because knowledge matters, preparation matters, documentation matters. And the truth is this: many parents lose not because they are bad parents, but because they walk into dependency court without understanding how the system works. So let's begin. The first thing you need to understand is that family court and dependency court are not the same thing. Family court usually deals with disputes between parents. Dependency court involves the government stepping into the situation because the government claims the child is at risk. That is a major difference. In family court, the dispute is usually between mother and father. One parent may claim the other parent is dangerous or unfit. But generally speaking, family court assumes parents have constitutional rights to custody and visitation unless evidence proves otherwise. Dependency court is different. Dependency court operates under California Welfare and Institutions Code Section 300 and related statutes. The court's primary concern is child safety. And once dependency jurisdiction attaches, the court has tremendous authority over your family. That means the court can order monitored visitation. The court can remove children from your home. The court can order counseling. The court can order drug testing. The court can restrict contact. The court can terminate reunification services. And in extreme cases, the court can terminate parental rights. Now, I want you to understand something very important. A divorce case can become connected to dependency court in many different ways. Maybe during the divorce, one parent accuses the other of physical abuse. Maybe a child says something at school. Maybe law enforcement responds to a domestic violence call. Maybe there is a substance abuse allegation. Maybe there are mental health concerns. Maybe there are claims of emotional abuse. Maybe one parent weaponizes CPS allegations during a custody dispute. And yes, that happens. The reality is that some people use allegations strategically during divorce litigation. Now, let me be clear. Some allegations are absolutely true and children need protection, but some allegations are exaggerated. Some are manipulated, some are false. And dependency court judges know that custody battles can create incentives for false accusations. However, even false allegations can become dangerous if parents fail to respond correctly. That is why strategy matters. That is why documentation matters. That is why preparation matters. Now, one of the biggest mistakes parents make is assuming that because they know the allegations are false, the court will automatically see the truth. That is not how litigation works. Courts decide cases based on evidence. And if the other side has organized evidence, written reports, witnesses, timelines, photographs, text messages, social worker testimony, therapist records, police reports, and school records, while you walk into court emotional and unprepared, you are already in trouble. That is the reality. So let's talk practically. What do you do when dependency court first enters your life? Step one is this: do not panic. Now, I know that sounds easier said than done, but panic causes parents to make terrible decisions. Panic causes parents to overshare. Panic causes parents to lie. Panic causes parents to destroy evidence. Panic causes parents to scream at social workers. Panic causes parents to violate court orders. And panic causes parents to damage their own credibility. The second step is understanding that everything you say can become evidence. Everything, every text message, every social media post, every voicemail, every angry confrontation, every interview, every statement to a social worker, every statement to law enforcement, every statement to a therapist, every statement to the child's school, everything can become part of the case. Now, this does not mean you should refuse to cooperate, but it does mean you need to think carefully before speaking. One of the most dangerous mistakes parents make is talking too much during investigations. Parents sometimes believe that if they explain enough, the social worker will realize they are innocent. Unfortunately, what often happens is that parents provide inconsistent statements, emotional statements, speculative statements, or statements that later get taken out of context. You need to stay calm, you need to stay factual, and you need legal advice as early as possible. The third step is preserving evidence immediately. This is critical. Start gathering documents. Start gathering text messages. Start gathering emails. Start gathering photographs. Start gathering medical records. Start gathering school records. Start gathering therapy records if appropriate. Start creating timelines. Start identifying witnesses, because dependency court cases move fast, very fast. And parents who wait too long to organize evidence often lose important opportunities. Here's an example. Suppose a parent is accused of being intoxicated around the children during an exchange. Now, maybe the accusation is false. Maybe the accusing parent made the allegation during a heated custody dispute. But if you immediately obtain surveillance footage from a nearby store, receipts showing you were somewhere else, GPS data, witness statements, and contemporaneous text messages showing normal behavior, that evidence can become powerful. But what happens if you wait 2 months? The surveillance footage may be deleted. Witness memories may fade. Digital records may disappear. That is why immediate action matters. The fourth step is understanding the importance of credibility. Judges evaluate credibility constantly. Social workers evaluate credibility constantly. Attorneys evaluate credibility constantly. And credibility is not only about whether someone is telling the truth. Credibility also involves consistency, demeanor, documentation, behavior, and reliability. Parents damage their credibility when they constantly change their stories. Parents damage credibility when they exaggerate. Parents damage credibility when they attack everyone involved in the case. Parents damage credibility when they violate court orders. Parents damage credibility when they post reckless things online. And yes, social media can absolutely destroy dependency cases. I have seen parents accused of substance abuse posting videos of themselves drinking during active dependency proceedings. I have seen parents claiming financial hardship posting luxury vacations online. I have seen parents violating no contact orders and then denying it while electronic evidence proves otherwise. Do not underestimate how damaging this can be. Now let's move into the substantive law. Substantive law refers to the legal standards the court applies to determine whether dependency jurisdiction exists. In California, dependency jurisdiction commonly arises under Welfare and Institutions Code Section 300. There are multiple subdivisions. For example, Section 300 Subdivision B often involves allegations that a child suffered or is at substantial risk of suffering serious physical harm due to a parent's failure or inability to supervise or protect the child. Section 300 Subdivision A can involve serious physical harm inflicted non-accidentally. Section 300 Subdivision C can involve serious emotional damage. Section 300 Subdivision D can involve sexual abuse. Section 300 Subdivision J can involve abuse of siblings. Now, here is what many parents misunderstand. Dependency court is often focused not only on past conduct, but future risk. That distinction matters. A parent may argue nothing happened, but the court may focus on whether there is a substantial risk something could happen. That means even without actual injury, the court can still intervene. For example, repeated domestic violence in the home can create dependency jurisdiction even if the child was not physically injured. Why? Because California courts recognize that exposure to domestic violence can place children at substantial risk of harm. Substance abuse allegations operate similarly. The court may examine whether alleged substance abuse creates an inability to supervise or safely parent the child. Mental health allegations can operate similarly. The issue is often whether the condition impairs parenting ability or creates safety concerns. Now let's talk about family law overlap. In divorce and custody disputes, California Family Code Section 3011 and related statutes govern best interest analysis in custody determinations. But once dependency jurisdiction exists, dependency court generally takes priority. That means the dependency judge may control visitation, custody, placement, and reunification issues. Family court orders may become secondary. This creates enormous frustration for parents who believe their family law case should control. But dependency jurisdiction changes the legal landscape. Now, another important legal principle involves the burden of proof. At the jurisdictional phase, the agency generally must prove allegations by a preponderance of the evidence. At disposition, removal findings may require clear and convincing evidence. These standards matter because they affect litigation strategy. Understanding the burden helps you understand how aggressively evidence should be challenged. Now I want to emphasize something very important. A dependency petition is not proof. An allegation is not proof. A social worker report is not automatically true. You have rights. You have the right to contest allegations. You have the right to cross-examine witnesses. You have the right to present evidence. You have the right to challenge hearsay in certain contexts. You have the right to counsel. And in many situations, you have appellate rights. But rights only matter if properly exercised. Now let's walk through the actual dependency court process. Typically, the process begins with a report to Child Protective Services. That report may come from a teacher, doctor, therapist, police officer, neighbor, relative, or one parent during a custody dispute. The agency investigates. That investigation may involve interviews, home visits, medical evaluations, school contacts, and safety assessments. If the agency believes immediate intervention is necessary, it may remove the child or seek protective orders. Then a dependency petition may be filed. Once the petition is filed, the first major hearing is often the detention hearing. This hearing occurs quickly, very quickly. And this is where parents often make mistakes because they walk into court completely unprepared. At the detention hearing, the court decides whether the child should remain detained or whether the child can safely remain with the parent subject to conditions. The agency will usually present reports. The parents may respond, attorneys may argue, the court may issue temporary orders regarding placement and visitation. Now, one strategic issue here involves whether the parent presents evidence immediately or reserves certain evidence for later contested hearings. That decision depends on the facts. It depends on the allegations. It depends on the strength of the evidence, and it depends on litigation strategy. After detention comes the jurisdiction hearing. This hearing determines whether the allegations in the petition are true. This is critical because sustained findings can affect custody rights, employment opportunities, reputation, future family court proceedings, immigration consequences, licensing issues, and even future dependency proceedings. At jurisdiction, the agency must prove the allegations. Witnesses may testify, documents may be introduced, cross examination becomes extremely important. Then comes disposition. Disposition focuses on what orders the court should make. Should the child remain removed? Should reunification services be ordered? Should visitation be monitored? Should counseling be ordered? Should drug testing be ordered? Should domestic violence programs be ordered? The court develops a case plan. Now, here is a major issue many parents fail to appreciate. Compliance matters. I understand that some parents feel angry about participating in programs they believe are unfair or unnecessary, but refusing services can seriously damage your position. Courts often interpret refusal as lack of insight. That is extremely important. Dependency court places heavy emphasis on insight. Does the parent understand the alleged problem? Does the parent acknowledge risk factors? Does the parent demonstrate willingness to address concerns? And over time, the court decides whether reunification should continue. Now, that does not mean you must falsely confess to things you did not do, but litigation strategy requires careful thinking. There are ways to comply strategically while still contesting allegations. This is why experienced counsel matters. After disposition, the case continues through review hearings. There may be 6-month reviews, 12-month reviews, and permanency planning hearings. The court examines progress. The court examines compliance. The court examines visitation. The court examines the child's well-being. Now, if reunification fails, the case can move toward termination of parental rights. That is why early strategic action is so important. The beginning of the case often shapes everything that follows. Now let's talk about evidence. This is one of the most misunderstood areas of dependency litigation. Parents often assume that if something is unfair, inaccurate, or hearsay, the judge will automatically disregard it. That is not always true. Dependency proceedings have unique evidentiary rules. Social worker reports are frequently admitted. Hearsay exceptions may apply. Children's statements may sometimes be admitted under statutory provisions. Medical records may come into evidence. School records may come into evidence. Police reports may influence the case even if no criminal conviction exists. So, what can parents do? First, understand the importance of objections. Objections preserve issues. Objections clarify disputes. Objections can limit evidence, and objections may become critically important for appeals. Now, I want to explain something practical. A good objection is not just yelling objection. A good objection identifies a legal basis. For example, hearsay, lack of foundation, speculation, relevance, improper opinion, authentication problems, leading questions. assumes facts, not an evidence, argumentative questioning. Now, dependency court judges often allow significant flexibility in evidence, but that does not mean objections are meaningless. Preserving objections can matter tremendously later. Let me give you an example. Suppose a social worker report states that the child said father hit mother repeatedly. Now, maybe the statement is inaccurate. Maybe the child was coached. Maybe the statement was mistranslated. Maybe context is missing. You may challenge reliability. You may challenge interpretation. You may challenge foundation. You may cross examine the social worker regarding interview methods. You may seek inconsistencies. You may present contradictory witnesses. You may present electronic evidence. You may introduce photographs or records. And sometimes expert testimony becomes important, particularly in cases involving mental health, substance abuse, child interview techniques, or allegations of coaching. Now let's talk about credibility attacks. Cross-examination is often one of the most powerful tools in litigation. Good cross-examination exposes inconsistencies. It exposes missing information. It exposes bias. It exposes exaggeration. And sometimes it exposes outright fabrication. For example, suppose one parent claims the other parent was constantly intoxicated during custody exchanges, but text messages from those same dates show friendly and normal communication. Suppose photographs contradict timelines. Suppose school attendance records undermine claims. Suppose medical records contradict injury allegations. These details matter. Now, another major evidentiary issue involves documentation. Contemporaneous documentation can be incredibly persuasive. Judges often place significant weight on records created near the time of events. Why? Because memories fade, stories change, litigation influences narratives, but contemporaneous records can appear more reliable. This includes journals, text messages, emails, calendar entries, receipts, medical appointments, therapy attendance, school communications, photographs, GPS data, phone logs, visitation records, drug testing results, counseling completion certificates. And I want to say something important here. Parents should never fabricate evidence. Never. Fabricated evidence can destroy your credibility permanently. Once a court believes you manipulated evidence, your entire case becomes compromised. Honesty matters, accuracy matters, consistency matters. Now let's discuss organization, because organization can dramatically affect outcomes. One of the best things a parent can do is create a master timeline, a detailed timeline, chronological, organized, accurate. This timeline should include major events, dates, court hearings, police contacts, hospital visits, school incidents, visitation exchanges, text messages, drug tests, counseling sessions, therapy appointments, protective order filings, and any important interactions with the agency. Why is this important? Because dependency cases generate enormous amounts of information. Reports become hundreds of pages long. Multiple hearings occur. Different attorneys become involved. Different social workers rotate onto the case. And parents who remain organized are better positioned to challenge inaccuracies. Here is what often happens. A social worker report contains an incorrect date. Another report repeats the incorrect date. Then a later report assumes the incorrect information is true. Suddenly, an inaccurate narrative becomes embedded in the case. But organized parents can identify inconsistencies. They can point to records. They can point to communications. They can point to contradictions. Now let's talk about witnesses. Witnesses can be critically important. Teachers, doctors, neighbors, relatives, counselors, coaches, friends, supervisors, childcare providers, therapists. These individuals may provide context that the court would otherwise never hear, but witness preparation matters. Witnesses should understand the importance of truthfulness. Witnesses should stay focused on facts. Witnesses should avoid exaggeration. and witnesses should avoid speculating about things they did not personally observe. One of the fastest ways to weaken testimony is through speculation. For example, a witness who says, I personally observed mother interacting appropriately with the child on multiple occasions is giving factual testimony. But a witness who says, I know father invented all these allegations because he is evil may appear biased and speculative. That distinction matters. Now, another practical point, do not assume the judge automatically knows your history. Many parents walk into court believing the judge will somehow intuitively understand years of context. That is not how litigation works. You need evidence, you need organization, you need strategic presentation, you need coherent narratives supported by facts. Now, let's discuss one of the most common issues connecting divorce court and dependency court: domestic violence allegations. Domestic violence allegations can dramatically alter custody and dependency proceedings. California law treats exposure to domestic violence very seriously. And importantly, dependency courts often focus not only on direct physical harm to children, but the emotional and environmental impact of violence within the household. Now, here is where things become complicated. Not every argument is domestic violence. Not every accusation is true. Not every police response proves abuse. And not every restraining order request is justified. But once allegations enter the system, they can shape the entire case. The court may issue emergency protective orders. The court may order monitored visitation. The court may require batterer intervention programs. The court may examine text messages, photographs, body camera footage, witness testimony, prior reports, and medical evidence. Now, let me talk strategically. Parents often make devastating mistakes in domestic violence cases because they react emotionally. For example, violating no contact orders, sending angry messages, showing up unexpectedly, posting online attacks, attempting to influence witnesses, or confronting the reporting party. All of this can severely damage your case. Another major issue involves mutual accusations. In many relationships, both parties accuse each other. Dependency court must then determine credibility, risk, and safety concerns. And this is where documentation becomes incredibly important. Photographs, medical records, witness testimony, police reports, prior communications, electronic records, 911 recordings, all of these may become relevant. Now, I also want to address false or exaggerated allegations. They do happen. And when they happen, they can be incredibly destructive, but the response must be strategic. You do not combat false allegations by losing emotional control. You combat them through evidence, consistency, documentation, witnesses, cross-examination, and careful litigation strategy. Another major area in dependency litigation involves substance abuse allegations. Now, substance abuse allegations can arise in many different ways. Maybe there was an arrest, maybe there was a DUI, maybe someone reported drug use, maybe prescription medication issues exist, maybe there were allegations during custody exchanges, maybe a child reported concerning behavior. Now, under California law, the issue is often whether substance abuse creates a risk to the child. That means the court examines parenting ability, supervision, judgment, safety, stability, and insight. One important practical point is this: if the court orders testing, compliance matters. Missed tests are often treated like positive tests. Parents sometimes believe avoiding testing helps them. Usually, it hurts them. Another important issue involves prescription medication. Some parents assume that because medication is legally prescribed, dependency court will not care. That is incorrect. The court may still examine impairment, misuse, interactions, dosage issues, and parenting impact. Now let's discuss strategy. Suppose a parent struggles with alcohol. One strategic approach may involve voluntary treatment, counseling, AA participation, therapy, consistent testing, and documented sobriety efforts. Courts often respond positively to proactive accountability, but denial without evidence can become dangerous. Now, this does not mean parents should falsely admit addiction, but strategic legal positioning matters. Remember, dependency court focuses heavily on risk management. Judges want reassurance that children are safe. That means proactive conduct can matter tremendously.